Good afternoon, good morning, and welcome to today's webinar, Maritime Straits in a Changing World Order. What is the future of the Strait of Hormuz and other maritime choke points? I'm Khansa Lakdami, Associate Professor at the World Maritime University, and it is so good to have you, so many of you, with us today. There are some 566 registered people with us today from across the maritime law community, the industry, and beyond. The topic before us is an urgent, and the timing could not be more relevant. Allow me first to introduce my colleague who will be co-moderating alongside me, Professor Hinin Yesen, who holds the Nippon Foundation Chair in Maritime Law and Digital Change here at the World Maritime University. Professor Yesen brings deep expertise in the law of the sea, maritime law, and digital transformation, and his questions later today will reflect that breadth. Welcome, Professor Yesen. We are also honored to be joined by the President of the World Maritime University, Professor Max Mejia, who will share some opening remarks with us in just a moment. Professor Mejia has led the World Maritime University through a period of remarkable growth and engagement, and his voice in these issues carries the full weight of WMU global mandate. Welcome, Professor Mejia. And at the heart of today's program is our keynote speaker, Professor James Kraska. Professor Kraska is Charles Stockton Professor of International Maritime Law and Chair of the Stockton Center for International Law at the United States Naval War College and visiting Professor of Law and John Harvey Gregory Lecturer on World Organizations at Harvard Law School, where he is currently teaching the law of the sea. A former US Navy officer and lawyer with tours in Japan and the Pentagon. His scholarship bridges the law of the sea, national security law, and the environmental law. His presentation today, titled Legal Vortex in the Strait of Hormuz, takes its name or title from one of his remarkable or landmark articles. And I cannot think of a better guide through the complexities before us. We are truly fortunate to have him with us. So, Professor Kraska, welcome. We are here today because a question that once seemed settled. Can commercial shipping move freely through the world's most critical waterways? Is no longer settled at all. The Strait of Hormuz is roughly 33 kilometers wide at its northernmost point. Yet, through that corridor passes approximately 1/5 of the world's oil supply every single day. It is in every meaningful sense a choke point for the global economy and increasingly a flashpoint for international law. Vessel seizures, naval confrontations, competing sovereignty claims, the norms that have long underpinned freedom of navigation are now under pressure in ways we cannot afford to ignore anymore. So this webinar basically brings together leading expertise to examine what is happening currently, why it matters, and critically, and most importantly, what legal frameworks and practical approaches can help restore predictability and the role of law in this vital strait. So welcome again to our webinar. And I will now hand over to my colleague, Professor Yesem, who will take us through today's agenda before we invite President Mejia to open the floor. Thank you.
Thank you very much, Kansa, and good day, everyone, and a warm welcome also from me. In the interest of time, I would turn directly to our proposed agenda now. In a moment, I will give the floor to the president of WMU, Professor Max Mejia, to provide us with some opening remarks. However, not more than 5 minutes, maybe even less than 5 minutes. I will then give the floor to our esteemed main speaker of today, to Professor James Kraska. After Professor Kraska's address, there is time designated for discussion, so for some questions and answers. My colleague Kansa and I will kick off the discussion with 2 questions that we have prepared. And please note that we would like to focus the discussion on the future of maritime straits, especially, of course, the Strait of Hormuz, which is very much in the news these days. We would also like to focus on related questions of freedom of transit for international shipping as governed by UNCLOS. You heard the number. There is a lot of interest in this webinar, and we have received a number of questions already in advance. Also, before we opened the webinar today, already questions came up. So the interest is quite high. And some of the questions that we received go actually beyond the level of what we can address in such a webinar. In addition to the applicable law, we would like to anchor the discussion, if I may use one German expression here, in Realpolitik. That means we shall base the discussion on considerations of the given real circumstances, factors, and developments now, rather than linking other broader political aspects here. In short, we would like to address reasonable legal approaches that can contribute to restoring an orderly flow of goods based on the rule of law, applicable for this highly important maritime strait, but also applicable for other maritime straits used for international navigation. With that being said, I would like to hand over the floor to the president of WMU, to Professor Max Mejia, who has now the floor.
Thank you, Professor Jessen. Esteemed colleagues and distinguished participants from around the world, it is both an honor and a pleasure to welcome you to this webinar with the theme Maritime Straits in a Changing World Order, hosted by the World Maritime University. The sea has always been humanity's great connector. It is the conduit through which energy, oil and gas, food, raw materials, and countless other necessities and commodities flow. It is the lifeblood of world trade and commerce, and it's an irreplaceable medium for achieving global prosperity and stability. Yet, economic development can only be driven on a presumed universal respect for mare liberum, the free and open seas, a critical and fragile presumption that has been met by a delicate combination of respect and challenge throughout the ages. And nowhere is its fragile nature more evident than along the world's maritime choke points. In current affairs, it has a specific manifestation: the Strait of Hormuz. The freedom of navigation and the exercise of unimpeded transit passage have not faced a challenge quite as severe and as consequential, at least in living memory, as in the Strait of Hormuz. This and numerous other challenges to the freedom of maritime movement do not unfold in a legal vacuum. They test the United Nations Convention on the Law of the Sea, the framework constructed with great care by the international community, which, together with the associated customary international legal regime, has underpinned peaceful maritime connections for decades. At the World Maritime University, we believe that understanding this legal framework and its vulnerabilities is not simply an academic exercise. It is a matter of practical and urgent importance. So today's discussion touches on issues central to WMU's mission. Our mandate, embedded in our nature as a postgraduate university of the International Maritime Organization, is to develop the human capital and institutional knowledge that the maritime sector needs to address the most pressing of contemporary issues. Geopolitical risk to maritime choke points is unquestionably one of them. And therefore delighted that we are joined today by Professor James Kraska, one of the foremost authorities on these matters. His availability to share with us his expertise could not be more timely. So for this, we are truly grateful. I would also like to sincerely acknowledge our moderators, Associate Professor Hansa Lagdami and Professor Henning Jessen, whose combined expertise in maritime labor law, maritime law, and digital change makes them the ideal guides for today's conversation. So for the rest of this hour, we will explore the legal regime of transit and innocent passage, the rights and duties of coastal and flag states, the implications of great power competition for multilateral norms, and what all of this means in practical terms for shipping companies, insurers, seafarers, and port operators around the world. The questions before us today are not easy ones, but these are exactly the kinds of questions for which WMU was established to engage, bridging law, policy, and the realities of the maritime industry in service of a safer, more secure, and more just maritime world. I look forward to a rich and illuminating discussion. Thank you very much for joining us.
Yes, thank you very much, Professor Mejia, for those timely and very inspiring words, linking our topic to WMU's mission as well. We now turn to the centerpiece of today's program. Professor Kraska, the floor is now entirely yours. I'm not sure who is sharing the slides. Is it us or you directly? But the floor is now yours.
Thank you kindly for that, Professor Jessen, and also thank you, Professor and President Mejia, for the invitation to the World Maritime University, and also to Professor Lagdami, my colleague, my co-author on a number of projects. It's really an honor to be able to interact with not just the fantastic world-class faculty of World Maritime University, but also the alumni and the students of WMU as the institutional world leader in developing capacity for maritime operations, maritime security, and environmentally sound and safe shipping. So yes, if you could bring my slides up, I would appreciate. And what I'll talk about is the idea of a legal vortex in the Strait of Hormuz, that there are some continuing legal issues that have percolated for decades before this current conflict. Next slide. And this conflict provides some opportunity for us to solve this vexing legal problem in the Strait of Hormuz. So this is one element of the relationships that are unfolding right now. Of course, we're in a period of armed conflict, which we hope ends very quickly, that we hope that the parties are close to reaching an agreement to end the bloodshed and stop the violence. But in the meantime, the law can provide a diplomatic language or diplomatic pathway to cement a peace and make it more permanent. So I'll just describe a couple of thoughts on that, and then I'm going to save lots of time for question and answer. So could you go to the next slide, please? If you look at the geography of the Strait of Hormuz, this is a strait used for international navigation in the UN Convention on the Law of the Sea. And of course, we are all familiar with the critical energy conduit that this serves. And it has long been an area of instability. And part of this is a result of differing legal interpretations. And so as we pay more for energy throughout the world because of this current conflict, we're sensitive to the importance of the rule of law in the Strait of Hormuz. The strait actually has two traffic separation schemes, a northern route that's 2 miles wide and a southern route that's 2 miles wide, and these are separated by a 2-mile buffer. And these traffic separation schemes were established through the general provision on ships routing, which is associated with or attached to the Safety of Life at Sea Convention. Both Oman and Iran, of course, are parties to the Safety of Life at Sea Convention. And in fact, the traffic separation scheme that we have in through the Strait of Hormuz was promoted or advocated by Oman and Iran in 1968. So these are the traffic separation schemes that were proposed by these two states and that the member states of the IMO adopted and that now apply to all states as a matter of treaty law. And so even though Iran is not party to the UN Convention on the Law of the Sea, it is party to the IMO Convention as well as the Safety of Life at Sea Convention. Next slide. Now, the legal vortex gets into the issue of, if you could go to the next slide, gets into the issue of the transit regime. That is, when I say regime, I mean set of rules that applies. And Iran has, from time to time, including during the negotiations for the Law of the Sea Convention, suggested that the regime of innocent passage applies rather than the more robust regime of transit passage. Of course, the key for transit passage is that it may not be suspended by the coastal state, such as Iran has purported to do in the current conflict. Now, remember, the current conflict has both the law of the sea overlaid with the law of naval warfare. Let's set aside the law of naval warfare, which governs the relationships between the United States and Iran, and that's a separate issue. But if we look at just the law of the sea, Iran is not a party to a conflict with numerous other countries, such as European countries, China, India, Japan, Korea, Australia. All these other countries, of course, are not party to the conflict, and they still enjoy their rights of navigation through the strait. Furthermore, Iran is limited through its ability to impose tolls or regulations or any type of control that would hamper or deny transit through the strait. Now, remember, though, Iran is not party to the Law of the Sea Convention, and so it says that actually these rights of transit passage are only held by states that are party to the Law of the Sea Convention. Neither the United States nor Iran hold that status. Next slide, please. So, in short, though, we can consider the transit passage regime to be a reflection of customary international law. Customary international law has two bases. The first is state practice, and the second is opinio juris. That's simply Latin, and it just means that there is a sense of legal duty or lawful right or legal obligation. So we have state practice combined with opinio juris that has made this regime of transit passage to be reflective of customary international law. So it has crystallized into customary law because it has been occurring and exercised for numerous decades. Furthermore, remember that Iran's claim of a 12-mile territorial sea is also reflected in the Law of the Sea Convention, and the 12-mile territorial sea is also customary international law. And that means that the regime of transit passage in the Straits, there are overlapping territorial seas with Oman and Iran because it is less than 24 nautical miles wide. The traditional transit regime of innocent passage in the territorial sea was exchanged during the negotiations for the Law of the Sea Treaty was exchanged or supplanted by transit passage with the expansion of the territorial sea. So Iran expanded its territorial sea from 3 miles to 12 miles in 1959. And from 1959 until Iran signed the Law of the Sea Convention in 1982, it recognized, of course, free navigation through the strait. And then since 1982, except for some brief interruptions, Iran has recognized the regime of transit passage through the strait. Iran also recognized the regime of transit passage through the strait when it was at war with Iraq for 8 years during the Tanker War. So the regime has been quite durable and reflects the state practice combined with the legal right, or the opinio juris, that enables all states to use this international waterway in accordance with the rules that are reflected in Part 3 of the Law of the Sea Convention. Now, occasionally Iran has reasserted its right to maintain only innocent passage in the strait, and there are occasional incidents throughout the years, and of course now very manifest in the current conflict, where Iran has, or the Islamic Revolutionary Guard Corps naval forces have interdicted shipping or harassed shipping in the strait. Next slide, please. So Iran has proposed a Persian Gulf Strait Authority to govern the strait. This is a new idea in which Iran is resurrecting its previous position during the negotiations of the Law of the Sea. The problem for Iran, though, is that this proposal was rejected by the conference, the third UN conference on the Law of the Sea. Iran had raised the prospect of the regime of innocent passage. It was not adopted by the conference. And then thereafter, Iran signed the Law of the Sea Convention. Now, Iran is not a party to the Law of the Sea Convention. It has only signed, but what this means is that it has never ratified the convention. Under the Vienna Convention on the Law of Treaties, Article 18, there is a good faith requirement that once a country signs an agreement, they have a duty of good faith not to undermine or defeat the object and purpose of the agreement. So Iran is not entirely free from the requirements of the Law of the Sea Convention. It has a duty not to undermine or defeat the object and purpose of the treaty. And next slide. Of course, the object and purpose of the treaty was to, in large part, resolve this vexing problem of the navigational regime through straits. And indeed, the convention validates the Corfu Channel decision, which ensured or guaranteed that all states have the right to transit through international straits. Next slide, please. So because of the dangers in the strait, there is this creation of a legal vortex, and it's a collision of these three regimes. There's the law of naval warfare, which we've set aside, and then there's the law of the sea. And the law of the sea has these two navigational regimes, Part 3 on transit passage, which I may suggest is reflective of customary international law, and which has some legal binding force even for Iran as a signatory to the Law of the Sea Convention, and in particular as a member of the IMO, having signed and agreed to the IMO Convention, as well as the 1994 when Iran signed the Safety of Life at Sea Convention. And so with that sort of legal overlay or legal introduction, I'd like to turn it back to our moderator, Professor Henning, and look forward to a discussion and any questions. Thank you kindly.
Thank you very much. In fact, it is my colleague who will take over first, but I have prepared two questions that I'm eager to discuss.
Thank you very much, Hinin, and thank you enormously, Professor Kraska. That was a remarkable and comprehensive overview of the legal landscape and the legal topics surrounding everything related to the Strait of Hormuz. So I will start with let's say a basic question before to hand over to my colleague, and then we will pick up some questions. We received so many in the chat from our attendees. So the first question basically is about the effectiveness of the application of the UNCLOS. So UNCLOS provides a clear distinction between transit passage in international straits and innocent passage in territorial seas. And your presentation has set out that framework with great clarity. But unfortunately, clarity on paper does not always translate into predictability on the water. And your view, does the current legal framework remain adequate to address the realities of modern maritime traffic in a strait as contested as Hormuz? Or are we reaching the limits of what UNCLOS as it stands can deliver?
Well, it's a great question. This is the perennial question that we face always in international law, which is that states are sovereign in the international system, and so it's very difficult to bind states. I would say that the question could also be applied, for example, to the United Nations. Despite all of its failings, nonetheless, this is the institutional architecture, the legal architecture that we have. And we do have principles and rules that provide a basis for diplomacy. So the law is not going to solve all of our problems, but it does serve as a basis for diplomacy.
Okay, thank you very much. I think I will leave it to Hinin, as he has kind of a complementary question related to this first question.
Yeah, and my first question is also linked to the presentation, because in more recent news, actually only a few days ago, Iran has created now officially this Persian Gulf Strait Authority. Basically, Iran has created a body to manage traffic now, at least that's what they assert, through the strait, and even combined with a Bitcoin-backed insurance service called Hormuz Safe, that seems to be for Iranian shipping companies for the moment. But my question actually is, how should the rest of the world react to such a development? It seems to me, although I saw today that 5 nations in the region officially reject this body. It seems to me that the rest of the world is basically ignoring this as noise. And I wondered, that's actually now my question, if there are some transits now where actually money is paid, for example, in Chinese yuan or in some cryptocurrency, that could be seen as a practice that is emerging, and not a custom, of course, but state practice, that Iran receives money for transits. So I wondered, shouldn't there be more vocal and explicit protests, diplomatic protest notes against the establishment of that authority and the powers that it seems to assert?
Professor Jessen, it's a wonderful question. So I think that states from Pakistan to China that are more friendly with Iran, as well as other states, have rejected the idea of a Persian Gulf Strait Authority. And so I anticipate that they will continue to hold the line. Iran will pay a cost if it maintains the present course. There will be countermeasures that other states, I would suggest, are going to extract some costs. Even a state that's friendly with Iran, such as China, will likely impose some sort of counterbalancing or countervailing measures if it accepts or complies with this new rule. Furthermore, in the long term, Iran is acting counter to its interests because there's already been a substantial diversion of oil out of the Strait of Hormuz and to alternative routes, and those will only increase. So Saudi Arabia, for example, is already providing 8 or 9 million barrels of oil a day, almost half of the amount that went through the Strait of Hormuz, simply through overland pipelines. One of the reasons that I think states have not sort of more loudly or more publicly stated this is that, first of all, it has just been announced, so states are determining like how they will respond. And then secondly, there's the overlay of the conflict. And so, there are states that are not entirely supportive of the U.S. War effort or armed conflict. And so I think for them, they would want to be a little more delicate or less insistent on this Persian Gulf Strait Authority. But I think over time, it will not be accepted. The precedent, the massive precedent of doing so is going to put at risk transit through all straits. And when Iran and other countries realize this, everything from the Lombok Strait to the Gibraltar Strait to the Strait of Malacca, I think that cooler heads will prevail.
Yeah, thank you very much. Kansa? I think Kansa has an issue with her speakers. Maybe I can just then add my follow-up question here. And this second question of mine has also been raised by a participant. So I can kind of catch now two purposes here. My question, but also a participant question. From an UNCLOS point of view, I mean, the legal situation is actually quite clear when it comes to maritime straits. They cannot be closed if they are for international navigation, and there's no legal basis for the introduction of any payments, tolls, and so on, fees, no discriminatory conditions. But the problem here is, or something that I wanted to raise is, we rely, you also said it in your presentation, very much on customary international law here. And looking forward to a solution for the future, there are people who think about a mechanism. Maybe it's too far-fetched to think of a contractual solution for the Strait of Hormuz, but at least to look at mechanisms in other parts of the world that provide for regional cooperation, like the Southeast Asian RECAP or the Djibouti Code of Conduct for East Africa, for trust building, cooperative threat reduction. I know, of course, this is not realistic now as we speak today, but since the current US president likes very much to think in deals, couldn't this be part of a peace deal if we take a positive scenario that there is a mechanism introduced for the strait that is to some extent modeled after other regional cooperation mechanisms? And I think the IMO would also be in favor of that trust building or threat reduction mechanism. So what are your views on modeling a solution for the Strait of Hormuz on maybe other parts of the world where there has also been tension?
Yeah, thanks for the question. So it's a great idea, and I think that once that there will be space for that once the shooting stops, once the armed conflict is resolved. I think it will be very difficult to to negotiate something like that while the conflict is going on, because
Mm.
both sides are invested in the military effort rather than in how to make peace work.
Yeah, I was thinking a little bit beyond after when there is basically trying to pave a deal or create elements of a deal, which also would include things like information exchange and cooperative threat reduction. But I understand it is currently a little bit far-fetched. Um, Kansa, you have your mic issue solved.
Yeah. So
Okay.
thank you very much, Henen, for raising this question. But I think we received almost two questions in the same direction. I will jump on another aspect, which is the human element. We have seen that seafarers, they are kind of trapped with the ship seizures in the region. And a lot of them now, they are lacking food, water. So we are not talking even about how to make them going back home. So there is a huge humanitarian crisis right now. So my question is really related to this aspect. So how our legal framework that we have now in place, including the MLC, how effective are. So we are not talking only about INCLOS. We are not talking about only about the IMO instrument. Now we are also talking about the labor framework that we have. So how we can also cope with this issue, and if the legal framework that we have as a whole now is sufficient.
Yeah, it's a great question, Professor Lagdami. And actually, it's quite apparent that the rules to protect seafarers are not effective in this case. We have some 18,000 seafarers that are trapped in the Gulf. And of course, many of them are getting in worse and worse circumstances. And so this is a humanitarian crisis. So I think that the Gulf states now only have the option of ramping up aid to these seafarers and providing kind of ad hoc admission and entry into port and providing repatriation for these individuals that are on board ships. Of course, it's quite complex because there's costs to be borne in all of this. And so it will have to take the states of the seafarers, Philippines and other countries, as well as the port states to treat this as essentially a natural disaster and provide the aid to the seafarers. I'm also heartened by the industry guidelines that have been released that emphasize, particularly in transit, safety of life is the number one priority. And so I think many of us hope this will end very quickly. Hopefully, it will end this week if we're very fortunate. But it has dragged on, and so now I think that states are planning for a longer term, and kind of deferred action in hopes that there be a quicker resolution.
Thank you. Thank you, Professor Kraska. I'm picking up now some questions from our audience. One of them that it's really looking for other solutions. It comes from a colleague from the Port Operations Ghana Port and Harbor Authority. As the geopolitical tensions increasingly disrupt major maritime choke points, how can ports, particularly in developing regions such as West Africa, use technology, data analytics, and strategic planning not only to respond to disruptions, but to anticipate and build long-term resilience against future global shipping uncertainties? I'm pretty sure, Professor Kraska, you will like to answer to this question because technology and everything related to how technology can help out is your expertise as well. So.
Thanks for the question. I'll provide just a thought, but then need to defer to you, Professor Lagdami, as one of the pioneers on the application of AI and seafarers at sea. I would suggest on the more material side that obviously this is inevitable that we have both ports as well as vessels that are autonomous. That is not going to change. Obviously, the mass code is coming to fruition and will enter into force. And so we will see more and more autonomy throughout the entire maritime supply chain. As far as the implications for seafarers and AI, I'm going to have to defer to you, Professor Lagdami.
Yeah, thank you very much, Professor Kraska. I believe in such a time of crisis, countries, it's kind of a reminder for all of us that we need to be ready what matters happened. And the investment in technology and the investment in research in some parts of the world is really essential. And this is one of the situations where it can be politically relevant for some countries to think to develop their ports, their infrastructure to be ready in case there is some issues in other regions, and direction or redirection of the global shipping to their region. So I hope that we answered to the question, and maybe Hinin, if you picked up any, we received so many.
Yeah, I'm scrolling here all the time through the questions. Maybe one observation and then one question linked to that. I note some participants have added questions about the big scheme of things. For example, the environmental impact of the blockade or of the whole situation, and also the fact that third-party countries are very much affected by the current situation. For example, also not everything is linked to oil and gas, but also the supply of fertilizers is very much affected at the moment. So some participants wonder if well, the question goes a little bit into the direction of compensation and liability, but I think that is very difficult to answer. Maybe you have a view on that. That's what I picked from the questions here. The wider fallout of the blockades, of both blockades, and how we should follow up on those.
These are wartime measures. So the blockade that the United States has imposed is a component of the law of naval warfare. It's a method of war, and it's lawful so long as the sole purpose is not to starve the civilian population. There's not evidence that that is the sole purpose of the blockade. Rather, it's because the economic sustainment of the armed conflict is provided through Iranian oil exports. And so the blockade of the anchorages, ports, and coastline of Iran is a wartime measure. And what we can just hope for is that there's a resolution to the conflict and stopping the bloodshed and the economic damage. And then that will lift that blockade. As far as Iran's sort of somewhat blockade, I mean, it has essentially weaponized its geography to harm states that are not involved in the conflict or that are interfering with states that are not involved in the conflict, including, let's not forget, missile attacks against more than a dozen countries in the region. So again, but this is part of the not lawful measures in armed conflict, but nonetheless, we have to just negotiate a settlement. In that regard, everybody can sort of prognosticate where they think it can land. I would just suggest that both sides have an incentive to reach agreement, particularly on of course, to save lives primarily, but on the economic side, there's harm to Iran, enormous harm to Iran, as well as harm to all countries, really, because oil clears at a market price globally. And so even a country like the United States or Norway that is self-sufficient in oil still feels the effect of the increased cost. So no one has been spared from this conflict.
Yeah. Thank you very much. I have a question really related to the last point, and it comes from Captain Ismail from Djibouti. So his question is basically a projection in the future. So knowing the current efforts on the fuel efficiency and green energy in line with the more sustainable business, do you think that in 10 years from now, Hormuz issue would have happened, or it would not be with the same gravity?
Well, I don't have a crystal ball any better than anyone else. I would say that sure, there is an effort to, as we all know, to reduce carbon and even decarbonize shipping by 2050. We'll find out sort of how aspirational that is 25, 23 years from now. We might expect that the Persian Gulf, Persian Gulf/Arabian Gulf issue can ameliorate somewhat because of alternative methods of delivering the oil. I still think the oil will be critical even 10 years from now.
Thank you. And I think because we are approaching a little bit to the end of this webinar, unfortunately, it's just 1 hour. It needs hours to discuss this issue. I will read another question in a positive tone, let's say. If there is no positive outcome from the legal and diplomatic efforts, what would be the next practical solutions? Could we see some kind of reorganization of logistics and search of alternative routes to return to the previous levels of energy and other resources supplies that we had before? And this is coming from Elisaveta. I don't know from which institution. Yeah, thank you, Professor.
That's a great question. Yes, I believe we are and we will. So even if this conflict is not resolved, for example, if it continues or the U.S. blockade continues, I think that other suppliers and alternative routes will fill this gap. And it's already happened. We're not actually feeling the full effect, mainly because the Gulf states are using alternative overland routes right now. And that will only accelerate. And then there are other countries that can bring online additional supply. And so I think that gradually the prices will soften, will weaken, even if the conflict continues. Yeah.
I don't know, Hinin, if you have.
No, I only have. I know that we are running out of time. I only have maybe a final comment from my side. A couple of days ago, or maybe 1 or 2 weeks ago, there were already some thoughts of I think a politician from Indonesia to discuss the Strait of Malacca. This has been firmly rejected to even think about introducing tolls or any kind of payment for other straits. So I wanted to end here on that note that the future path cannot be that the straits, the maritime straits, the choke points of this world will be subject to a payment regime. And I think this should have also become clear from our discussion of today. So these are already the final words of thanks from my side. And I would leave the closing speech to my colleague Kansa, please.
Thank you very much, Hinin. And I think this last point has been raising a lot of discussions, on how all the straits around the world, how the operationally and the practicality of their operations can be saved in terms of crisis. So, Professor Kraska, I'm not sure if you have any last thoughts and more specifically about practical solutions, because, with every day we have a new development in this crisis. So sometimes we say that, now it's more calm, and then the next day we wake up with some news that they are changing again the landscape. So before to conclude and before to close this webinar, I would like to invite you to just share with us what are your thoughts, if you think that it will be resolved, this crisis anytime soon.
Thank you. So just my final thoughts would be that I'd recommend that states do more in international institutions, in particular at the International Maritime Organization, and there are other UN bodies such as the Food and Agricultural Organization, the International Atomic Energy Agency. These UN bodies, particularly the IMO, where member states have an opportunity to express their views, in particular on the Strait of Hormuz and the legal status or the legal regime that I've laid out here, and Iran's obligations to respect the rules that it cannot suspend for the vast majority of nations that are not party to the conflict. Again, the U.S. and Iran is a separate armed conflict issue, and with that regard, we could set it aside. But Iran's legal duty to all these other countries in the world persists. It may not suspend those legal duties, and so I would encourage states to intervene at the IMO and other UN bodies to hold Iran to the agreements that it has concluded. Thank you. And thanks very much again for the opportunity from World Maritime University to be able to speak to all of your faculty, students, and your wonderful alumni throughout the world.
Thank you very much, Professor Kraska. And we could see that it's a challenge and a vision at the same time that deserves to be heard well beyond this hour. So on behalf of President Mejia, Professor Yesen, and the entire World Maritime University community, including our alumni and students, I want to express our sincere gratitude to Professor Kraska for a keynote of exceptional depth and clarity. And to all of you participants, colleagues, practitioners, and students for joining us from across the globe. What today's discussion has made abundantly clear is that the legal framework governing maritime straits is not a relic of Cold War diplomacy. It is a living system under active stress. The Strait of Hormuz is not simply a geographic bottleneck. It is a test of whether international law can hold when geopolitical forces push against it. WMU will continue to engage with these questions through research, teaching, and convening like this one, because the stakes for seafarers, for global trade, and for the rule of law at sea could not be higher. A recording of today's webinar will be made available through WMU website, so please share it widely. These conversations need to reach out policymakers, practitioners, and the next generations of maritime professionals. So thank you very much all, and good afternoon, good morning.